Welcome to the Sam the Answer Man podcast. For 30 years, Sam Ventola has been an attorney, hearing officer, professor, and mediator. Now he's here to answer your legal questions. Sam the Answer Man, law made simple. Here's your hosts, Sam and Gina Ventola.
Hi, everybody. Welcome to Sam the Answer Man podcast. I'm Gina.
And I'm Sam.
Sam, how you doing?
Doing really good. How about you?
I'm doing pretty good. I've been kind of thinking about contracts lately. As business owners, we get a lot of contracts thrown at us, whether it's leases, whether it's company cell phone service. There's just a lot of stuff. Terms of service on software. Can I get, a thumbs up on that one? So can you tell us, from a legal perspective, what we as business owners should look at?
Well, there are a lot of contracts that are like user agreements with software or social media sites and stuff like that people don't read. And that's sort of understandable. But if it's something that's important to your business, it's essential that you actually pay very close attention to the contract provisions and watch out for the things that business owners are finding are being put in contracts that are hurting them a lot.
So like what? So what are some of the things that we business owners should look for?
Well, I would say the biggest thing is that people sometimes don't understand that when you have a final written contract, that is your deal. And any promise that was made to you before that contract is not going to be enforceable. It's not even going to be admissible in evidence that you had this promise. So if somebody says, here's the contract, just sign it. Don't worry, we're going to do this other thing like we promised. Walk away. That thing has got to be in the agreement, because any evidence, even if you have it in writing, even if you have emails or letters where they say, oh yeah, we'll do the deal this way, don't worry. If in the contract it's not there, those emails or letters are probably going to be not only not enforceable, but inadmissible in evidence. You've got to make sure that the final written contract contains any promises that you believe are part of the deal.
So number one, written over spoken.
Yeah.
So it just doesn't matter what they say. Is that right?
It's
got to be in writing
and
in the contract.
And the other side of that is, if there's something in the contract that you don't think should be there, and they say, oh, don't worry, we're not going to enforce that provision in the contract. That's not really there. That's just on our form. Just sign it. Again, you cannot sign that document, because if it's in the contract, even though they made a promise to you outside before that they weren't going to enforce that provision is going to be part of your deal, and it's going to be enforceable. So you have got to make sure that both in terms of what's expected to be promised in the contract is in there, and things that don't belong in the contract are not in there.
So what's another one? So we know the first one is it's always what's in the contract, not what they tell you. So what's another one?
Another one that I see causing big problems for particularly small business is forum selection clause or venue selection clause.
So wait a minute, that's a kind of a legally term. What do those mean?
So basically these are clauses that say that if there's a dispute under the contract, any litigation has to occur in a certain forum. And the problem comes up when that forum is someplace totally foreign to where the deal is centered. So if you've got a contract in your state to do something and it's entirely within your state, they may put a forum selection clause in there that's back in their home office state, or maybe they'll deliberately put the forum selection clause somewhere where they know it's going to be inconvenient for you to litigate. It might even be a foreign country. And so these kinds of clauses, I constantly advise clients to avoid, because if you're called upon to litigate in some jurisdiction where you're not going to be prepared to litigate, you've effectively given up any rights you have under the contract. You're never going to be able to enforce that contract if you can't go to that state, hire lawyers who probably be very expensive in another state, have to litigate in that other state. It's a mistake. And the other thing is, they can sue you in another jurisdiction, ask for anything. And if you're not prepared to go there and defend, you're going to lose that case. You're going to have a judgment entered against you. So it is very, very important that you not agree to a forum selection clause unless it's somewhere where the deal is centered, or at least somewhere where your business will be prepared to litigate if you have to.
So kind of like, I mean, this is an odd example, but in the Facebook terms of service,
Right.
I get mad at Facebook and want to sue them.
Right.
Right in the terms of service, it says you have to do it in California and San Marin County. Not here.
And that's one thing for Facebook. I mean, if litigating against Facebook is going to be important to your business, that's one thing. But most people, you know, if you have a problem with Facebook, you'll simply move on and do something else. You're not going to think about actually litigating against Facebook. That's one thing. But a thing with somebody who's your business has a very important deal with, you can't put up with that kind of thing. You cannot agree to a forum selection clause that's going to require you to litigate someplace else.
All right. So number 2 is knowing the location, where the forum or venue clause is in the contract and where it says it.
Right.
Right. So
Right.
we're number 2.
All right.
So give me number 3.
You know, closely related to forum selection clause is arbitration clause. A lot of contracts, business contracts, will have a clause that say, if we have a dispute, you have to litigate any disputes in arbitration. Now, the first problem with arbitration clauses could be the same as with the forum selection clause. These arbitration clauses might require you to arbitrate in some far-off jurisdiction, which is probably going to be difficult or impossible. But the other problem with arbitration clauses is that most of them apply a very expensive arbitration company. AAA, the American Arbitration Association. Here we have Judicial Arbiter Group, or JAMS, Judicial Arbitration and Mediation Service. Litigating in these arbitration jurisdictions is every bit as expensive as going to court, and more so, because the difference between going to court and this arbitration is now you're paying the judge or judges, sometimes there's 3 judges, and a very large amount of money for them to work on the case. And it's going to make it very impractical for you to be able to pursue your rights if you have a bad arbitration clause. Now, there can be good arbitration clauses if there's a good provider. For example, the Better Business Bureau. I'm an arbitrator with the Better Business Bureau, and they provide a very economical, low-cost arbitration thing that actually is a very good idea for businesses. And I do recommend a Better Business Bureau arbitration clause. But if you've got one with the AAA or JAMS or JAG or anything like that, stay away, because you're essentially making it impossible for you to defend your rights because of the costs that you may be facing.
So number 3 is avoid arbitration clauses if possible.
Or at least bad ones.
All
So,
right. Give us another one.
Another thing that business people should always look for in a contract are one-way provisions. And these could be anything from attorney's fees provisions or interest provisions or penalty provisions or deadlines, things in the contract that only apply to you but not to the other side. Because if they have that, if they have a provision that says you're required to do this and I'm not, it's probably going to be pretty unreasonable. They're going to say, they're going to make very onerous requirements on you, knowing that they don't have to worry about complying with them. So anything that looks like it should be bilateral, a confidentiality agreement, an attorney's fees provision, should not be one way. Should not be just your company has to pay those things or your company has to meet that obligation. You got to make sure that those things are mutual so that both sides are subject to the requirements in case they're very burdensome. So always avoid one-way provisions that only apply to you but not to the other side.
So number 4, avoid one-way provisions, especially if they only apply to you, right?
Yeah.
Okay. Give us another one. Let's let the healing begin.
Well, another thing that I see, particularly in commercial leases, is a lease that will require the tenant, so your business, to start paying rent as of a certain date. But maybe there's construction going on or remodeling, and the landlord is not required. There's no date set by which the landlord is required to produce those premises to you in a condition ready for you to do your business. And I've seen clients who are called upon to pay rent month after month after month, and the landlord's still hasn't gotten the property ready, but they're paying a high commercial rent for property they can't use. You always want commercial leases. The forms there are a ton of provisions in there that are very onerous to the tenant, and they should be always reviewed carefully. But particularly as to this issue, never sign a commercial lease that requires you to start paying rent, possibly before you get possession of the premises. So that's something definitely to look out for.
So that's number 5, is rent without premises. So if you can't move in right away, don't sign it.
Or I mean,
unless there's what?
Or maybe the rent doesn't start until it's done. If you know that it's going to take time to do some improvements or so, just have it set forth when it's going to be done and make sure you're not paying rent before it's done.
And going back to what you said originally, if the landlord tells you one thing,
right,
like when you can move in and the lease says something else.
Definitely, it's an example of that. Yeah, don't count on promises outside the contract for that. Make sure it's in writing in the contract. You know, this kind of brings up, you know, a sort of point that goes over all of this, which is if a contract is important to your business, it's important enough to have an attorney review it. Because, you know, a lot of times people, they don't really understand reading these things, how it's going to play out. And there are a lot of lawyers out there who do commercial work, who all they do is, you know, review contracts. But there's also, I think, some value to a lawyer who has been in litigation, because when a lawyer is in litigation, they have seen how these things go south, and they've seen how certain clauses can come back at somebody in a way. Basically, they know what to look out for in a contract.
Because they've sued on them, right?
They've sued, or they've been sued, or they basically had to deal with this clause. How does it play out in real life under an actual dispute? And so I do think it's a very good idea, especially to have a person who's experienced in commercial litigation review your contract to make sure that there are not any nasty surprises in there, like the things we've talked about, but like a dozen other things that, you know, would have time on this video to talk about that are also potential landmines in your commercial agreements.
Well, thank you, Sam. That was very informative. In addition to Sam spreading his knowledge here, he has written a great article, and you'll like this. It's called What Kenny Rogers Can Teach Us About Contracts. So why the reference to Kenny Rogers?
I think it's because in that song, it's like you have to know when to walk away and know when to run. When to run,
like in some of these clauses that we have in there, right?
So again, yeah, you have to be in a position to decide if the other side refuses to renegotiate that. Is this something that breaks a deal? And it very well may be, if it's something that's, again, is going to result in a contract that's going to prevent you from getting what you expect to get for your business.
That's awesome. So if you go to our website, ventolalaw.com, down in the bottom right, we have some of our recent blogs listed, and one of them is What Kenny Rogers Can Teach Us About Contracts. So if you want more information, there's great information there. There's also, if you have questions about contracts, you can contact Sam, email him at sam@samventola.com, or you can request an appointment on our website. Now, you do pretty cool phone consultations, right?
Yeah, if you have a question, you know, I do free phone consultation. So if you have a question regarding commercial lease or any other aspect of business law, feel free to give me a call and I'll tell you what I can.
Because we recognize you're busy and we value your time. And we don't want you to think that we have to drag you downtown to come to our office to meet with Sam. So you can meet with Sam over the phone. You can request your appointment from our website. If you do click on the Contact Us tab, just fill that out. I'll reach out to you. We'll get a time set up and it'll be great, right?
It'll be great.
So thank you, everyone. Check us out on social media, Facebook. We have a Facebook page called Sam the Answer Man. We also have one called Ventola Law. So if you have questions, you can message us on Facebook. You can contact us through direct messages on both Instagram and Twitter. So let's talk.
Thank you.
Thanks, everybody.
If you would like to discuss your legal issue with Sam, please contact Ventola Law at 303-864-9797 or check out our website at www.ventolalaw.com. Ventola Law, mediation and legal representation at an expert level.